Well, let me break that down into two parts. One, if I'm just going to pursue the assets of the debtor within the jurisdiction where the judgment was entered originally, I don't have to necessarily file a new lawsuit at all. I can commence my post-judgment relief generally 14 days after entry of the judgment, unless the debtor appeals and files a supersedeas bond for the entire amount of the judgment, plus interest, plus attorney's fees that would accrue during the lifetime of an appeal. And that's an ideal situation, because while you will be sidetracked and have to do work on an appeal for a period of time, assuming the judgment is upheld, your judgment is going to be fully paid. There are some circumstances, even in the state where the judgment entered, where you in fact will want to file a separate lawsuit. For example, if there are fraudulent conveyances of property that you want to tie up the property and go after it and secure the property back, and maybe even have additional judgments entered against those who were in cahoots with the debtor, who got the property under improper circumstances that constitute fraudulent conveyances. And this becomes a much more substantial and detailed analysis, driven by the facts of your case, of course. Now, there are some times where the other aspect of this is a consideration of what assets do we believe the debtor has or controls, directly or indirectly. Have we really exhausted this person for the time being, as in a setting of just coming out of bankruptcy? And do they need time to rebuild and gather more assets that we can go after? So we always look at that too. We don't just rush to say, oh, let's go, if there's no reason to go. So we like to, with you, come to a place where we can make together informed business decisions.